Good afternoon, ladies and gentlemen. Welcome to the graveyard slot. When the organisers told us that we were going to be talking about governing laws straight after lunch, I thought it was some kind of joke. And that suspicion was confirmed when I was told my speakers were going to be an Englishman, an Irishman, and a Scotsman. The joke, I think, backfired because our original Englishman had to drop out and the organisers had to stand in to fill that slot. So we're going to address something loosely resembling governing laws from the perspective of those different jurisdictions. And as we're just back from lunch, I thought I could start with a joke. 3 lawyers met in a pub for lunch. 2 of them produced sandwiches from their briefcase. The Englishman was horrified. "You can't eat your own sandwiches," he cried. The Irishman and the Scotsman looked at each other and shrugged and swapped their sandwiches. What a promising start. I'm going to invite my panel to introduce themselves. Dean needs no introduction, so he has a blank sheet to talk to you from the perspective of the Englishman.
Thank you, Kim. I'm going to share some reflections as an Englishman sitting as a tribunal on governing law. Just to let you know, I'm standing in for Charles Brown. Charles did a paper. I'm not going to read it. I'm not familiar with all the contents of it, and I wouldn't do it justice. But he was going to look at the comparative benefits of adjudication in the UK, and his premise was that we're extremely lucky in the United Kingdom because the Construction Act allows us to refer any dispute, not just a payment dispute. And I think that marks out the United Kingdom from most of the other jurisdictions with statutory adjudication. He's got some wonderful quotes in here. I'm not going to try reading them out of context. It wouldn't do it justice. Though in closing in his paper, he mentions what the Supreme Court observed. It is a conspicuously successful addition to the range of dispute resolution mechanisms available for use in what used to be an over-adversarial litigious environment. And of course, that's referring to adjudication. So, would anyone like to tell me what governing law is? I know we've got some very prominent lawyers here. Is anyone awake and would like to volunteer what governing law is? Shall I pick on someone? No? All right, I'm not going to embarrass anyone. I think you all know what governing law is, so I'm not going to dwell on that point. I'm going to kick off talking from my own experience. I'm sure, like most English-trained and qualified tribunals, I don't need to be told what English law is or what it means by an expert, whilst it may be helpful for me to receive legal submissions during the course of the matter. I certainly don't need a professor, barrister or solicitor to appear as an expert on English law. If I sit as an adjudicator appointed by an English AMB for a matter in England, I'm aware that no matter what governing law is stated to apply, you can't contract out of the provisions of the Construction Act. It's territorial in its application. And I'm sure you'll all be aware, section 1047 says this part applies whether or not the law of England and Wales or Scotland is otherwise applicable in relation to the contract. Thankfully, I've not had many English adjudications where a foreign governing law has been the governing law. And when I say that, I've had experiences of Scottish governing law, Irish governing law, but I haven't had any of the civil code jurisdictions. I'm going to touch upon that later on in my talk. I infrequently have had adjudications in England with a Scottish governing law clause. Similarly, I've had adjudications in Scotland with an English governing law clause. This is primarily because the parties were using their standard form contracts and hadn't given sufficient thought into the governing law. You know, it could be a Scottish contractor who's normally doing work in Scotland, and then he's pass that down to the contractor on a project in England or subcontractor, which isn't always advisable. What I have found, though, is that the parties representing themselves often don't understand or know the governing law, but muddle on free. Those parties that are using lawyers will rely on their legal representatives to point out what they need to know in terms of the law. Those types of adjudications haven't been a problem for me so far in my career, though one day they may be a problem. I'm sure you're all aware and recall a recent case of Multacus Construction and Paolo Castelli. In that particular case that went to the TCC for enforcement, there was a governing law provision of Italian law. It went through for enforcement. It was enforced. I'm not going to tell you about the case. But if I'd been the adjudicator in that case and the parties hadn't used a legal expert, I would have probably looked to use my own legal expert to explain to me what the ramifications of having Italian governing law was. We're very lucky, both the Act and the scheme give the adjudicator the power to take the initiative in ascertaining the facts and the law. Similarly, I can decide to utilise an expert, legal advisor or assessor. The only condition upon me doing that is giving the parties notice of my intention. I do not have to ask them for permission. I give them notice. I can do that if I think it's appropriate. What I have found, though, in my career is where matters become extremely complicated is when you're sitting overseas. If I'm sitting as an arbitrator, the parties appearing will usually lead with expert evidence on governing laws where necessary, and this will be extremely helpful for myself and my colleagues who will not often be from that country or region. This is, of course, in addition to oral and written submissions. A different problem, though, which I've found, is when I sit as a dispute board members. Quite often the parties don't have legal representatives, and based on my own experience, rarely feel the need to make adequate submissions on what the implications of the choice of governing law are. Similarly, they don't call expert evidence in support of those submissions, which is extremely unhelpful to a tribunal dealing with a governing law they're not familiar with. The last thing you want to be doing is trying to get an English translation of a civil code and then believing that you're going to actually correctly apply that. It just doesn't happen in the real world. In terms of the FIDIC contract, the 2017 form with the FIDIC Red Book provides that the contracting governing law shall also apply to the DAAB agreement. What's unhelpful is that they say, if I'm appointed as a DAAB, at the outstart, I have to agree with the parties, my fees, and also I have to agree the remuneration of any expert whom the DAAB may want to consult. Now, quite often, if a board's a standing board, you're not going to have opportunity or know what disputes are going to come out. How can you possibly agree what expert you're going to use and remuneration for them? You just don't know. You're appointed as a standing board. I think it's important to highlight this anomaly because it does cause issues. The procedural rules that are in the 2017 form provide I can use a legal expert, and as I touched upon, with the approval of the parties, and it's in the powers of the DAB. The biggest issue that I find in that type of environment is that parties usually by that time can't even agree the colour of ink in a black and white document, which means they're not going to agree when you say I'd like to call an expert. So it almost defeats having that provision in there. In the United Kingdom, I think we're extremely lucky we've got the provisions of this scheme, which is totally different to the way that FIDIC have decided to set it out. I can give them notice and call an expert. And what I want to emphasise is that parties and their representatives must give consideration to expert evidence where an issue is impacted by the governing law. If you get an Englishman, it is likely they will allow matters to progress on an adversarial basis, and the burden will lie with the party to support the assertions they make. So, if you're involved, different governing law from your tribunal, do you give consideration to, is it something that can be dealt with by legal submission, or is it something you need to call expert evidence on? And that's all I'm going to say at this point in time. Thank you.
Thank you for that. It is actually quite interesting how often foreign influences infiltrate UK adjudication. We tend to think of it as essentially an English jurisdiction, but of course, even now we still procure materials from abroad. And if, for example, a bit of processing plant has been shipped over from France, it's not unusual in your adjudication to find a load of emails in French. Whereas in arbitration there are elaborate procedures for agreeing translation, unless you've had the foresight to include it in your terms and conditions, there'll be no such procedure in adjudication. So thank you for the English perspective. I now want to ask our resident Irishman to step up. James Bridgeman has the initials SC, Senior Counsel, and he wasn't required to change them on the passing of the Queen. I used to have some really smart initials, KF, KQC. I've now turned into something that sounds a bit like a fast food outlet. Let me hand you over to James.
Good afternoon. I decided that I'd talk primarily about construction adjudication in Ireland when I was invited to participate in this panel. But just very quickly before I do, Ireland is a plain vanilla uncitral jurisdiction. It is plain vanilla because that's what we asked for when it was first introduced in 1996 for international disputes, arbitration of international disputes. And that was continued into 2010 when it was updated and extended to both domestic and international disputes. So it's a plain vanilla uncitral jurisdiction. And will remain so. We have a Mediation Act. Mediation is regulated in Ireland, and that's for another day. And moving specifically to the world of construction, there's always an unusual aspect about the Irish industry is that there's a preference for conciliation, and there has been for quite some time. And I don't really know why, but I suppose you'd all know Professor Bunny, and he was very involved in FIDIC, and I would have thought he was very influential in the thinking on construction disputes in Ireland, and so with conciliation became the dispute resolution process of choice, really, including for the state, because the state had always had a problem trying to get civil servants to agree to settle something, and so they have a unique rights-based form of conciliation for state contracts, which facilitates the decision maker within the public service because they have a rights-based recommendation. Moving to adjudication, it took 20 years for adjudication to be introduced in Ireland. The 2013 Act was brought into effect in 2016, and what was produced is something very, very recognisable. The mandatory adjudication is available, specific to construction contracts. Their provision for interim periodic stage payments. Following the request, the responding party is expected to explain why monies are being withheld, and I'll come back to that. The right to suspend work, the strict time limits for 28 days, 42 days, what's agreed by the parties. Adjudicator appointment is by agreement with a mechanism for default appointment, which I'll come back to as well. And then the adjudicator's decision is binding but not final, typically a sole adjudicator. Parties go back to back on costs. So everything I've said there, you're familiar with, and what I'd like to emphasise within this is that if you're adjudicating in Ireland, you'll have the same job as if you were adjudicating in England. The difference is the context. And Ireland has a written constitution, and the written constitution will always impact on legal procedural matters. And Article 34 says that justice shall be administered in courts established by law, by judges appointed in the manner provided by this constitution. So justice must be administered by judges, but then Article 37(1) says, nothing in the Constitution shall operate to invalidate the exercise of limited functions and powers of a judicial nature, other than in criminal proceedings. So the categorization of the adjudicator's role has a constitutional context, which is it's the exercise of the administration of justice by somebody who is exercising limited functions of a judicial nature. And that impacts not on the job you're doing, whether you're looking at delay, disruption, all the smash and grab and all the rest. Not on that, but what you are. You're, if you like, in an elevated position in the law. Now, the consequence of this was that at a very early stage, you see, up until 96, we had contractual adjudication. It made its way in. It was very familiar. All Irish practitioners are very familiar with the UK because we work in 2 jurisdictions in the main. And so we were very familiar. And, of course, Peter Coulson's book was the Bible, still is the Bible everywhere. So what happened at a very early stage was, to my surprise anyway, because of this situation, because it's a constitutional concept, because it's legislation, and also because the legislation provided for the appointment of a panel of adjudicators by the minister. Now, that meant with a chair. So there is this person who's the chair of the panel, the minister's panel, and there's 36 of us who are members of that panel. So 36 of us, and I see a number of us here in the audience. So effectively that gave an opening at an early stage, and I was the defendant in the case O'Donovan and Bunny and Bridgeman, and Niall Bunny was the chair of the panel, and I was the second defendant. Responded in a judicial review, and that was seen to be a way to go to challenge the appointment at the very beginning. Now, since then, some question mark has been put over whether or not it is the appropriate way to go, whether it is a public law thing or a private law thing, and that remains to be litigated. And the person who put the question mark there was Mr. Justice Gareth Simons, who is now in he controls the High Court list for adjudication. So all work will go to him, and he'll really put a stamp on it in the same way as Peter Coulson put a stamp on it over here. The second thing within the Constitution is the question of confidentiality, because as I said earlier on, the Constitution says that justice shall be administered in public. So if this is an administration of justice, it doesn't. It must be in public. We don't have John Doe cases in the same way as they have in other jurisdictions, not allowed. And family law, limited circumstances, sex cases, limited circumstances on the criminal side. But generally, you can't go in camera. And so that may have an impact, but it hasn't had an actual impact on anything that I'm aware of myself yet, but I just flag it for you. Another thing is that there was an understanding, since a case going back to the the days of the arms trial, for those of you who are historians, in Ray Haughey. And there was almost a very, very strong belief that you have a right to an oral hearing in Irish dispute resolution. And that wasn't an absolute right. It never really was, but it was believed that you could always get an oral hearing in anything once you asked for it. But in fact, it is more nuanced than that. And Gareth Simons has pointed that out in a recent judgment, that there isn't an automatic right to an oral hearing. So, as I say, it's a common law jurisdiction, and with the result being Ireland and being where we are geographically and historically and politically and all the rest, and being the second oldest common law jurisdiction in the world, we have always looked to the courts of England, who have a much heavier caseload. A lot of Irish legislation was based, even since independence, on English legislation. The Irish Copyright Act was actually an infringement of copyright in the English Copyright Act, which made life very easy, because the thing was that the issues that came up had been litigated in London. So that's always been great. But Gareth Simons said in a recent case, he said, "There's an understandable temptation for practitioners and judges in this jurisdiction to borrow from this extensive learning that in Coulson's book, when interpreting and applying the Construction Act 2013. The case law from England and Wales must, however, be approached with a degree of caution. This is because there are significant differences between the legislative approaches adopted in the two jurisdictions. There are also significant differences in the procedure governing the enforcement of the adjudicator decision. These distinctions are all too easy to miss, in that many of the concepts underlying the UK legislation seem so familiar to us." That's in Aiken Construction. Now, I'm saying that, and then he went on in that case to list a number of issues. But I'd really like to emphasise that when you're sitting as an adjudicator, it doesn't really make a very big difference to you, because they tend to be procedural issues that are there. In substantive issues, though, one of the major differences is the scope, because in Ireland, a party to a construction contract has a right to refer for adjudication in accordance with the Act any dispute relating to payment arising under a construction contract. Now, that's narrower than any dispute that you have in English legislation. But everyone has always dealt with that by saying, sure, every dispute has to do with payment. You know, delay and disruption, that has a payment issue because you refused to pay because of... But the point is that there are potentially declaratory actions that may arguably be outside the scope of adjudication in Ireland. It'll be well flagged if it comes across your desk, and just to be aware of it. I made some other notes here, but I think what's important is that the courts have been very supportive of adjudication and arbitration. They're very, very supportive of both of those. Mark Sanfey, Mr. Justice Mark Sanfey, has the arbitration list, and Mark is a construction lawyer. Mr. Justice Simons has the adjudication list, and he came out of a planning stable, so he's well used to tribunals of one sort or another, and the scope and using tribunals and tribunal procedure. So it's in a safe pair of hands. But I very supportive, but I wouldn't call them deferential. So I don't really have the measure of Mr. Justice Sanfey yet. But in Mr. Justice Simons, I wouldn't certainly not deferential, because in O'Donovan and Bunny and Bridgeman, that case, it took 2 years for that to come through. That's a problem. And that's why the eyebrow was raised, because it happened during COVID and it went into judicial review, which meant leave, and I had a stay that was lifted once during the procedure. It took me 2 years before the stay was lifted, and I had 5 days to finish left in the 28 days or the 42 days to finish my decision. So, but I wouldn't call it deferential, because in the course of that case, the judges looked into my decision on whether or not I had jurisdiction. Now, there's no competence, but there was a decision that you'll read, Mr. Justice Moore at the time, and you'll see that he just completely, he didn't consider the reasons I gave for continuing before I was stayed. So I wouldn't call it deferential. And then in another case that I just mentioned, in Acon Construction Services, similarly, the court has said that the issue that was there was whether or not a true value decision should have been made by the adjudicator. The adjudicator applied Grange developments and just gave a smash and grab order, take your order and come back when you've paid it type of decision. He said he enforced that decision. He didn't give smash and grab the imprimatur, or the if you like, the default decision, his imprimatur. He just said that the decision was not did not offend due process, that did not offend fair procedures. He said that was the only thing before him, and he gave the applicant the order. But he did raise a question as to saying that a full consideration of that could only properly be carried out in substantive proceedings initiated in respect of the adjudicator's decision. Now, I don't want to get too technical about this, but it seems to me that some of the statements in that case are begging more different types of applications to be brought, and it hasn't happened, so I'm not going to go into that. If you invite me back and it happens, I'll tell you about it. The adjudication then, I'll just give you 2 minutes. The chair of the panel has gone out. Bernard Gogarty is the chair, and he has to report or give a report to the minister every year. His present report is due any day now, so maybe the first week in November will be a lot for us between the Queen Mary report and Bernard Gogarty's report coming out at the same time. But he went out to the stakeholders, and we on the panel have been asked to give our views on how it's going. And so will there be an adjudication 2.0? I doubt it, to be honest with you, because to try to get parliamentary time for primary legislation, I think construction has had its chance. What is, at the end of the day, really so special about a construction person not being paid rather than some other person not being paid, because everybody needs to be paid at the end of the day, and that's a view that has been expressed by one member of the judiciary in a lecture. So it goes on, and I have to quote from Seamus Heaney, because I'm Irish, and we have to quote from Seamus Heaney every time an Irish person gives a speech. And it says, since when, he asked, are the first line and the last line of any poem where the poem begins and ends? So it's a continuing thing. It didn't start with the act. It didn't finish with where we are now. And so an English woman, a Welsh woman, and a Scots woman, right? And they died, and they went up to St. Peter. And St. Peter said, you all voted for Brexit. You can't come in here. I said, but I let you in, provided that you can explain the mystery of the Holy Trinity. And one of them said, well, I'm English, she's Welsh, and she's Scots, and we all have an Irish passport. So the thing is that the Brexit lives on, you know, and in an Irish judgment, whether it be in arbitration or in adjudication, it is the judgment of an EU court under the Brussels regulation. And at the end of the day, again, that doesn't impact on you or I being an adjudicator in any procedure, but the consequences of the order is much more easily enforced if it need be in an international context. But unlike arbitration, you can't go forum shopping in adjudication, because the adjudication it's an Irish construction contract, as you know, an English, Scots, Northern Irish construction contract, in the same way as people might go hunting around for an order in arbitration. Thank you.
Thank you, James. Rising admirably to the challenge there. I do think it's interesting when we look at how other jurisdictions have adopted adjudication, where they managed to build on the mistakes of the UK jurisdiction, pick out the good bits and leave the mess behind. And the suggestion that the legislation might be reviewed, of course, reminds us of the changes to the Housing Grants Act, where the general industry response was, just when we worked out what the payment provisions meant, they came along and changed them. So now I'm going to turn to Scotland, if I may, and ask Brandon Malone to give you his perspective. Brandon may be known to you as a leading light in Scottish arbitration. He also managed to deliver UKA, finally, after I lost count of how many times it had to be moved because of the pandemic. He may well tell you about that, but I invite him to take the stage.
Thank you, Kim. I wasn't going to speak about UKA, and sadly I haven't prepared any jokes either. I feel quite left out. I should have thought of something. Never mind. Yes, I am Brandon Malone, and I do arbitration, and I'm also an adjudicator and a FIDIC adjudicator, which I'll talk about a bit. The term UK, which we've heard a lot today, and UK jurisdiction, what have you, there are, of course, a number of jurisdictions in the UK. People say UK, they generally mean England and Wales. I do have to point out that Scotland is part of the UK, at least for now. I'm not making any political points. Scotland is a different, I'm not joking, Scotland is a different legal jurisdiction for many purposes. It is a mixed civil law, common law jurisdiction, as is Mauritius, we heard earlier. Certainly I got taught Roman law at university. I've pled Roman law in court. But after 300 years of a common parliament, obviously there's a lot of convergence. And where Scots law is the governing law, there are a few differences and divergences in construction, but actually not that many. Scots law and English construction law are essentially the same. We use different words so that English lawyers have to pay us to tell them what they mean and keep us all in our little closed shop. I say that, I'm also a barrister down here, so I'm kidding myself. But the adjudication regimes in particular are just about identical. I'll talk about them a bit, but essentially there's not enough of a difference between Scotland and England in adjudication. not really in construction law, generally to form a full paper, really. So I've decided to take the UK government minister approach and ignore the question and talk about something else completely. Sort of. So what I'm going to do is briefly look at the Scottish position, but then I want to compare adjudication in the UK with FIDIC adjudication. So, the Scottish position. We have the Act, the 1996 Act. I was involved in one of the first adjudications in Scotland in '98 after that came in. The regime, as I say, is almost identical. We have a separate scheme, the Scheme for Construction Contracts Scotland. You can go through and try and spot the differences. It seems to me it's mostly words being rearranged, essentially the same document. There are some cultural differences, perhaps because we come at things from a different cultural background, and we do things differently in court, and we don't have things like, we don't have discovery, for example, in the same way in Scotland. I know this is adjudication, not court, but that doesn't tend to inform attitudes. I've found, because I do adjudicate down here as well as north of the border, I found there's more of a tendency to have hearings in cases of any size in Scotland. But that's not always the case. I had quite a big hospital PFI dispute recently where the parties didn't want to have a hearing, and that was fine. There's differences in enforcement, court action, of course, different court procedure than you would have in England and Wales. There's also a thing called registration of the books in council in session, where you're formally recording a document, but that does require the consent of the other party, and of course that's never given, so that's more of a theoretical difference. And then there are some defences available to an award, like balancing of accounts and insolvency, which I won't get into the technicalities of. So that's essentially the Scottish position, not radically different. And indeed, I very frequently, when I sit as an adjudicator, I will have English solicitors and other solicitors and non-solicitors appearing before me telling me what Scots law is, and that's fine. That's the adjudication regime. But I want to talk a little bit about the dispute board procedure, and obviously we've heard about that already today, but I want to compare it with statutory adjudication. And obviously, under FIDIC, we have dispute avoidance and adjudication boards. As I say, I am a FIDIC certified adjudicator, but equally, I've never been appointed as one, so what I'm saying to you is theoretical, and there will be better qualified people in the room to tell me where I'm getting it wrong. But that's, so under clause 21 of FIDIC 2017, looking at the definition of disputes for that purpose is very broad. A dispute is any situation in which one party makes a claim against another, which might be a claim as defined in the general conditions on the matter to be determined by the engineer or otherwise, and a claim as defined there is a request or assertion by one party to the other for an entitlement or relief under any clause of the general conditions or otherwise in connection with or arising out of the contract or execution of the works. So probably even a broader definition of a dispute than we get in adjudication. And you'll all remember there used to be a lot of disputes about, is there a dispute, and has a dispute crystallised, and what have you. And you see less of those these days, but I think under the FIDIC regime there'd be even less of a chance of trying to argue there isn't one. So the appointment, the DAAB is to be appointed within the time stated within the contract, or by default 28 days after the contractor receives a letter of acceptance. So that's a theory. You get a standing dispute board as soon as the contract gets put in place. But again, of course, as we heard, very often that's amended and it doesn't happen until a problem arises, and perhaps not even then. So the DAB either comprises a sole member or 3 members. So obviously a key difference there, 3 members opposed to a sole adjudicator under statutory adjudication. The 3 members, each party selects one member for the agreement of the others, and the chair is appointed with the agreement of the other party's members. And each party is responsible for paying half of the DAB's remuneration. Now, if there's any failure to appoint, then obviously an appointing entity appoints, and that could be FIDIC or UK Adjudicators or RICS, CIR, whoever. Now, an interesting distinction between statutory adjudication and DAB is the dispute avoidance procedure. So if the parties agree, they may jointly request the DAB to provide assistance and or informally discuss and attempt to resolve any issue or disagreement that may have arisen between them during the performance of the contract. Contrast that with adjudication, where generally speaking, everyone is walking on eggshells around natural justice issues. Everyone's terrified to get any sort of preliminary view from an adjudicator in case it gives grounds to challenge down the line for them having made up their mind or being biased. Another really interesting feature of DAB under FIDIC is that where the DAB becomes aware of such an issue or disagreement, it may invite the parties to make a joint request. Now, I don't have any direct knowledge of this having happened. I was speaking to a FIDIC adjudicator earlier, and they hadn't actually seen that happen in practice. But I think that's very interesting. And to our, certainly the common law mind, the idea of a dispute board going out and inviting parties, well, what about this issue? What do you want to do about it? I think there'd be a lot of concern about that. And again, going back to governing law and culture, there is in some culture, and we see this in arbitration particularly, where there's conciliation built right into the arbitration, and no one has a problem with the tribunal making suggestions, trying to sort things out with parties, then getting on with it and issuing an award if agreement isn't reached. Whereas in common law jurisdictions, there is this natural justice concern about, well, we may have said something to you that we regret, we've tainted the process now, you need to leave and we need to get another tribunal in. So cultural aspects which FIDIC, perhaps with its roots, is less concerned about. But even if there is this advice given, then if the DAB is not then bound in any future dispute by any view or advice given, even where that's set out in writing. So a very interesting feature, I think, of DABs when you look at it with reference to statutory adjudication. So the reference is set out in writing. There is an obligation on both parties promptly to make available to the DAB all information, access to the site, appropriate facilities as the DAB may require, and the parties are obliged to continue with their obligations under the contract whilst the reference is dealt with. The DAB decisions to be completed within 84 days or such other period as the DAB may propose and both parties agree. Now, obviously, that's a much longer period. One might argue a much more sensible period than statutory adjudication in the UK. Certainly my experience of adjudication is that for anything of any size and complexity, parties are always or usually happy to extend that by quite a bit, and quite often these things take 2 or 3 months or even longer. I had one that was 6 months long. And of course, sometimes one party is keen to keep it to the bare minimum, won't grant any extensions, and then questions about whether it's possible to complete that arise. Another interesting distinction with a DAB is that they're entitled to retain their decision pending payment of their fees, something a statutory adjudicator can't do. And if that means that the decision is published later than the agreed 84 days or longer period, then that does not invalidate the decision. So the decision of the DAB is binding on both parties and they're obliged to comply with it, whether or not they object to it. This, of course, is also theoretically true of an adjudicator's decision. If payment is required by the decision, it becomes due immediately without a certification or notice. And the DAB has the discretion to require security to be paid if there is a sum due and there are grounds to believe that the payee will be unable to repay that sum in the event that the decision is reversed in a subsequent arbitration. And of course, this is a big issue we see with statutory adjudication, people fighting tooth and nail not to pay because they're worried that they'll not be able to get their money back, particularly where there's been a smash and grab and everyone knows that that's not the final account that's going to come out in the wash down the line, and there's a risk of insolvency. So that is catered for in the DAB. If parties are unsatisfied with the decision, then they can serve a notice of dissatisfaction. And if there's a failure to give a notice within that 28-day period after the decision, it becomes final and binding on both parties. Now, that's, of course, not the default position with statutory adjudication. It is binding, but unless that is built into the contract, like you see with NEC contracts, it does not then become final and can be challenged at whatever point down the line, subject to, of course, time bar considerations. And a further step in the DAB process is that where there is a notice of dissatisfaction with the DAB decision, then both parties are obliged at that stage to come together and try to resolve matters amicably, even at that stage. However, arbitration can be commenced 28 days after the decision, whether or not there's been an attempt to settle. So finally, I guess the distinction is on enforcement. Obviously, in the UK under the Act, the courts have been extremely supportive because they've referred back to the intention of Parliament and the policy of cash being the lifeblood of the industry and what have you. So there is that policy imperative that payment is made and adjudicators' decisions are complied with and upheld wherever possible. But that's not the case around the world when you're dealing with DAB decisions in particular. It doesn't have that statutory regime behind it. Certainly it's got the intention of the parties so far as it's expressed in the contract, but it doesn't have a statute behind it. And in some places it can become very difficult to enforce a DAB decision, particularly where it hasn't become final and binding. So if you object to a DAB decision and there's then an ongoing arbitration, whilst it is in theory binding on the parties, in practice you're going to struggle to get a court to enforce it pending the later arbitration decision. However, since DABs are generally used on longer term projects, if it's a decision that's come up during the course of the contract, then since the decision is going to bind the engineer, then that's really how enforcement of that decision is going to be achieved rather than by the court. So that's really all I wanted to say about that. If anyone wants to hear more about Scots construction law or Scots adjudication, I can certainly answer questions about that too. Otherwise, thank you very much.